Hello, everyone. Harry here to talk about the day we probably knew was coming. Judge Eileen Cannon's dismissal of the indictments, the strongest of the four cases against Donald Trump, throwing in co-defendants Carlos de Oliveira and Walt Nauta for good measure. All right. Here's the first thing I want to say about this 93-page opinion over which she's obviously been laboring for a long time, or someone has, law clerks and the like. And this is the motion that she invited amici to come in and argue in her court very, very unusually. It doesn't really make sense to think about this and criticize it as law. There are cites in there, there are sentences, there's reasoning, of a sort. But really, it's a completely result-oriented piece. And, we can talk about cites and analysis and her, what she purports to say is important. But this opinion just doesn't turn on whether the important sentence in U.S. versus Nixon is dictum or isn't dictum, or doesn't turn on, whether 515B is an authorization or not. It turns on what we just have to say, and it's a sort of indication of how much the Trump world has and would wrench the law that we've taken so long to see what's in front of our eyes, which is a result-oriented judge looking to please her patron and potentially be rewarded for it. It doesn't even make sense to give it a paragraph by paragraph kind of refutation. Nevertheless, let me tell you what it purports to be. Well, what it purports to be is a high-minded, highfalutin, constitutional, august pronouncement of the important structural provisions of the Appointments Clause, which is the clause in Article 2 that specifies that there are officers of the United States. If they are principal officers, you've got to let Congress have a hand in appointing them. Think about an ambassador. If they are inferior officers, unless it's been otherwise provided for by Congress, you also have to let Congress have a hand in confirming them. The analogy here to special counsels, and let me just say that her opinion would completely wipe clean the entire slate of special counsels everywhere, including other cases, including the one appointed her for Biden and the one appointed for Vance, just the whole, for Mike Pence, the entire area of law that is our effort now to keep politics out of important cases the slate would be just wiped clean. But zeroing in on the issue here, it's that the Appointments Clause says that Congress may vest the appointment of inferior officers, may by law vest the appointment of such inferior officers as they think proper in the president alone. So who are inferior officers? They're non-principal officers. A very good example is United States Attorney, which I was, and which special counsels often are analogized to. Those are nominated by the president and confirmed by the Senate, but there are scores of examples where Congress has vested the appointment of such inferior officers by law. So her opinion comes down to this. There is no law, and the Jack Smith proffered 5, 2 of which seem quite strong. There is no law that actually vests the appointment of a special counsel and the Attorney General. Therefore, it had to be done by Congress. Therefore, it violated the Appointments Clause, and therefore, remedy, dismiss the case. That's the holding, okay? And now the first thing to say about it, this is not a constitutional holding. This is an interpretation of several statutes as to whether or not they provide for an appointment power within the Attorney General. So, for example, there are really a couple that are big, but here's the one that the department relied particularly on. It is 515B, and I'm having to move to it in her very long pseudo-scholarly opinion. 515B says that each attorney specially retained under authority of the Department of Justice shall be commissioned as a special assistant to the Attorney General or special attorney. You may remember the special attorney designation that has come up in the Weiss prosecution of Hunter Biden, which similarly would go by the boards here. What does she say about these attorneys retained by the Department of Justice? That refers, says Judge Cannon, to attorneys that were previously retained in a different section. That is not an authority to retain given by Congress to the DOJ. But a really important one that you can't leave alone, and that courts for 50-some years have taken as an authority here of different kinds, is in United States versus Nixon. She has a 20 or so page section about why an important statement in Nixon is dictum or not. So the concept of dictum. The decision may be stated in the opinion, but it's not central to the opinion. So the statement in there just doesn't matter. And here is the statement. The court says in the Nixon case that Congress has vested in the Attorney General the power to appoint subordinate officers to assist him in discharge of his duties, citing these very statutes, right? Couldn't ask for a clear statement from the U.S. Supreme Court, which has been, just taken as canonical for years and years and years. Not to Judge Eileen Cannon, who goes into great lengths to say, well, they didn't really need it there, and it wasn't part of the question presented anyway, therefore it's dictum. Okay, so there's more, much more, but basically she finds no statutes, including the two that are proffered mainly by the Department of Justice, give authority from Congress to Merrick Garland, to the Attorney General, to appoint a special counsel. Therefore, the special counsel was not appointed by law within the meaning of the Appointments Clause. And then also that the Supreme Court statement in the unanimous Nixon opinion that's been taken as unquestioned authority, that's just dictum. Okay. Remember now that this is the very issue that Justice Thomas concurs especially on in the immunity case. So this is the sort of final point I want to emphasize in this first video. This has really, really a bad odor about it of a justice writing a concurrence, and which Judge Cannon has, who is a district court judge, let me say again and again and again, not to her to overturn Supreme Court authority. And she calls this instead a question of first impression, but that's because she calls Nixon dictum. Anyway, Thomas has this concurrence on this very point. The concurrence itself, by the way, you could say bizarre or you could say tendentious in the sense of being designed precisely for the motion that already was in front of Justice Cannon, because Thomas agrees with everything that the court has done, that Chief Justice Thomas does, and then in this kind of, academic, brandy-sipping way says, I write just to, talk about or explore some ideas about, here's the exact way he puts this sort of casual process. I write separately to highlight another way in which this prosecution may violate our constitutional structure. So Thomas, who is wont to issue these tub-thumping proclamations about how one or another fundamental precedent or proposition of law doesn't count, even here is just this sort of speculative kind of after-dinner drink discussion. And importantly, even he doesn't go out on a limb of saying that this is accurate. So really, Judge Cannon has just grabbed this for all it's worth. Here's what Thomas says. I'm not sure that any office for special counsel has been established by law as the Constitution requires. And then he talks about why and ends up saying it is difficult to see how it's established by law. And, the court, to be sure, he deals with the Nixon dictum or what, anybody would have to. And then he talks about separation of powers, concerns, like you need a vigorous executive. But even he doesn't make the holding that Cannon does. So she's gone running with it for all it's worth. So look, final point here, you could call it a long pseudo-scholarly legal opinion that just fails to come to grips with, important precedent on the other side. There are, small kind of margins, including opinions at the margins by well-known extreme legal thinkers. Doesn't make them wrong, but it sure doesn't make them right, that she relies on. You could call it that, or you could call it what I think it is, which is the first opinion of Project 2025. That is an opinion that simply disregards the law and supplants for the law the principle that we're supposed to expect the Department of Justice and the entire executive branch to run on the basis of, if Donald Trump returns to office, namely loyalty to Donald Trump, law be damned. Really shameful day for the federal judiciary. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.